This week, we're discussing boilerplate. This is the part of a contract that comes at the end of the document. Typically, after you've gone over all of the other terms and conditions, who's doing what are they doing, where are they doing it, when, all of the 5 W's of a contract that we'll talk about in a few weeks. The boilerplate, as the name implies, is the part of the contract that you can just skim over and sign. It's what lawyers use to make them feel good about themselves charging a lot of money. Wrong. So a long time ago, the boilerplate was pretty similar contract to contract, but there are a number of provisions in it that really can affect the rights and obligations of parties underneath it, and you need to take a look at them. There are 4 provisions in particular that do have some variation contract to contract and can affect you. They are waiver, the right to assign, the governing law and venue, and force majeure. Waiver. So when you have a contract, there's rights and there's obligations. Now, sometimes in the course of doing business with a customer or client for a long time, you tend to kind of get lax on some things. Maybe your payment terms are 15 days, but with this particular client, you let them go 30 days routinely. At some point, that customer, that client will be able to argue that you have waived the 15-day payment terms and can no longer enforce them. And now in the course of dealing, you've created a 30-day term. A waiver provision in your boilerplate will prevent this. This is a provision that states just because one party does not always enforce a right or obligation does not mean that they have waived the ability to do so in the future. So these are really important, especially when you're entering into contracts with customers that you think are going to be long-term. It's also important to think about which party can waive. Is it going to be a mutual waiver or only one? So the right to assign. Assigning a contract means you're taking your legal rights and obligations and handing them fully over to another party. There are a number of times where this comes up, but the most common is a merger or an acquisition. So if your company is either merging or being acquired by another company, you want the right to assign your contracts to that new company so that they can then take them over and continue to provide service to your customers. That's a lot of the value of your company is their client base. But clients don't always want that. Sometimes they have hired you because they like you. Maybe they like something specific you do. They like working with a small business and don't necessarily want to go to that big business. So there is sometimes pushback on the right to assign. And it's, again, important to know if it's mutual and if it is complete or if it can only be done in certain scenarios. The third is governing law and venue. These are really 2 different provisions that get kind of slammed into one. Governing law means which state's law will control in the case of a conflict under the contract. Even though we're the United States and we have federal laws, under the federalist system, the states can have all kinds of different laws depending on the area of law. Sometimes it's subtle differences, sometimes it's huge. And so knowing which state's law is going to control is really important. Sometimes people will just throw out Delaware or New York because it sounds good or it's somewhere in the middle. But doing that means that you could be changing a right or obligation under your contract without really realizing it. And then venue is where disputes will be held. So we all hope that we don't get to the point of having a dispute under our contract. But if we do and we end up in court, the venue provision tells us where that's going to happen. And this usually gets so granular as not to just the state, but the county. And of course, it's advantageous to have the venue be where your business is headquartered so that you're not having to add the time and expense related to traveling to and from a court case. Typically, these are the same state. They don't have to be, but making them different has its own set of issues, and I would highly suggest you talk to an attorney before you do that. Finally, number 4 is force majeure. This is everyone's favorite topic recently with COVID and the pandemic. Force majeure essentially is the recognition that there are forces so far outside of the control of each party that they might affect the party's ability to perform under the contract, but there's nothing the party can do. Some force majeures are very short, some are extensive and list out a number of different all-inclusive lists of things that can apply. So it's really important to read the force majeure, know what events apply, what don't apply, and then to also make sure that if this is a contract with a customer, that you're not allowing them to waive their obligation to pay just because there is a force majeure event. You want to make sure that if they still have access to their bank accounts, that they can pay you. So if you have questions about Boilerplate, feel free to reach out. As always, it is Kelsey at schaffnerpllc.com, here on Instagram, Facebook, and Twitter at schaffnerpllc.